Hi, and welcome to another Thursday webinar from the Center for Agricultural Profitability at the University of Nebraska-Lincoln. I'm Ryan Evans, a communications specialist with the center, and you can always find an updated schedule of our upcoming webinars as well as recordings of our past webinars on our center's website at cap.unl.edu. Just look for the webinar page there, and you see that address on the screen. And today we're going to talk about the concepts of estate planning versus succession planning, because farms and ranches require more than just a standard estate plan. Understanding the difference between estate planning and succession planning is crucial. And this distinction is unfortunately often overlooked until it's too late. So in this webinar, we're glad to hear from Jessica Groskopf, an extension educator, an agricultural economist based in Scotts Bluff, who'll be diving into the key differences between estate and transition plans and outlining important considerations to ensure that you have the right plan in place for both your assets and your operations future. And we invite any questions that you might have during the webinar to be typed into the Q&A panel or the chat box, and Jessica will answer those before our time is up today. So Jessica, thanks for presenting today, and I'll turn it over to you.
Awesome, Ryan. Well, thanks for having me today. And I want to start out by stating that I am not an attorney and I am not an accountant. So today is not legal or accounting advice. I would encourage you that you think about the concepts today as an educational resource, and then you go to your team of experts, which will include an attorney and an accountant, and discuss your specific situation and scenario with them directly. So I've been out across the state the past few months, and I've been teaching farm estate and transition planning quite a bit, and I cannot get this phrase out of my head. And one day I was sitting in a workshop and I realized that every farmer or rancher needs an estate plan, but not every farm or ranch needs a succession plan. And what I mean by that is that you as an individual 100% need an estate plan. That is absolutely correct. But succession planning is different than estate planning. And succession planning is the process of moving the actual business from one set of owners and managers to the next. And more, I am running into farm and ranch families across Nebraska who do not have the next generation coming back into the business, or they don't have someone who's going to take over their farm or their ranch and leave it as a separate business from, let's say, another business that's existing. And I'm not here to sway you one way or another of how you should pass on your business or your assets. But I want to make the clear distinction between estate planning and succession planning. And I want to make sure that's really clear. And I might also use the word transition planning instead of succession planning here. But really, what we're looking at is that difference in what types of planning you are doing, either to make sure that your assets go to the right place or to make sure that that business survives to the next generation. So just some real clear definitions so that we're all on the same page. Estate planning is the process of arranging for the care of a person at the end of their life, the settlement of their debt, and the distribution of their assets remaining after death. Transition planning is a strategy to ensure the continued leadership and management of a business after key individuals are no longer able to fulfill their roles. Okay. So that key distinction there, estate planning really deals with death. Transition planning says, how does that current owner or manager step back without stepping away? Okay, step back without stepping away. So the goals of estate planning, when I work with farm and ranch families, a lot of times we're talking about making sure assets go to specific heirs, right? This piece of property goes to this person, or this vehicle goes to this person, right? We're also talking about minimizing taxes and potentially avoiding probate. And those are all things that come along with estate planning. Your goals might be slightly different, but those are traditionally estate planning goals. On the transition planning or succession planning side, we need to talk about ensuring that that business survives. Okay. So that survival goes beyond, did this person get this asset, right? It's, does that person know how to manage that asset and use it efficiently and effectively to earn a living and to maintain that business over time? So when we start asking these kinds of questions, really, when we're talking about estate planning, the real question is, what would you like to happen to your assets at or after your death? What would you like to happen to your assets at or after your death? And often, the second question is, are you the last farmer or rancher in your family? And the reality is, for more and more Nebraska farms and ranches, we are seeing that fourth, fifth, and sixth generation being the last generation to operate that farm. Do you have someone coming back into the business? That's the question. If you don't, we're going to focus more on that estate planning, making sure that you survive to the end of your life, and then we effectively distribute your assets at your death. If we're transitioning, if we're transition or succession planning, we are saying, what would you like to happen to your business during your life and after your death, right? So for the foreseeable future, how are we going to manage this business? And do you have someone coming back or already in that business? So if we're bringing back children into that business, how are we both working together? How are we both making decisions? How are we both moving this business forward and making sure that it survives? So I want to be very, very clear here that everyone needs an estate plan. However, those who plan to pass that business, and the true business, not just land, not not just that asset, but truly being the farmer or the rancher on that farm or ranch, they need a transition plan. Okay. A lot of times when I work with farm and ranch families, we're so worried about death, we forget about transition. And that's critical. When you get to 60, 70, and 80 years old, we need to make sure that that next generation is ready and prepared to take over that business and to help it survive. Okay, so succession planning includes estate planning. Okay, succession planning 100% includes estate planning. However, it also includes things like business planning, transition planning, and then as well as asset or excuse me, as well as sunset planning in there as well. And if you watched one of our previous webinars from the Center for Ag Profitability, we go into those other planning types in more detail than we will tonight or today. But do know everyone needs an estate plan. Some people will need a succession plan. Okay. So as I stated at the beginning, you are going to need a team of individuals around you to help you with this process. Whether you are doing estate planning or you are doing transition planning, you need a team of advisors. Most farm and ranch families get the top two. They know that they need an attorney, they know that they need an accountant, but then there might be other people who are on this planning team that we need to know, we need to like, and we need to trust to help us through the process. Okay. So again, if you're doing estate plans or if you're doing succession planning, we need a team for both of those. Now, when it comes to estate planning, it's probably actually a little bit more straightforward on what we are asking them to do. It might not cost us as much to actually get just the estate portion of that plan in place. However, if we're doing succession planning, We are going to be spending a significant amount of time with these people. We are probably going to be paying fees in advance, right? For them to assist us with this process. The other thing about succession planning is that we also might need more than just an attorney and an accountant. On the screen, I have banker, I have financial planner. You might also need an insurance agent. You might need a family mediator. You might need a family facilitator. So this team could be pretty broad depending on who you need to make your plan successful. When it comes to this team, I would not hesitate at all to also allow them to talk to one another or have meetings with you and your family with these professionals. So, for example, that attorney and that accountant speak each other's language. They know the laws, they know the implications of some of the decisions that you're trying to make. And sometimes it's easier to send them a question and say, I want to know the options to address this issue that we're facing. Can you provide me, you two talk together and provide us or me with a list of what solutions are able to help fix this problem that we are facing. And that allows them to kind of go back and forth um, and come back to you and provide you with options. Now notice I did not say in that example, tell you what to do. Okay? This is your team. You pay their bills, you pay their fees. Ultimately, it's your decision. It is your decision on what you do with your assets and what components are in your plan. If you are in a situation where you feel like you're being told what to do, I would encourage you to think about the fact that you are the CEO of this farm or this ranch. You are the owner of this farm or this ranch, and ultimately the decision is yours. If you do not understand what they are offering you or what tools they are giving you as options, I really, really would encourage you to ask them more questions, to spend more time with them, and make sure that you know and you understand what those options and the implications of those options are to address the scenarios that are at hand. So I'm going to pause here and take any questions. Yes, the recording of this webinar will be on our website sometime tomorrow, as well as the slides. Okay, so let's jump in to estate planning. And I want to spend some time here because it really is important. And every single person, I don't care if you own a farm, a ranch, or not, but if you are an adult, you 100% need an estate plan. Okay. I don't care how much asset you own. I don't care how complex your life is. You need an estate plan. Okay. So what are the components of an estate plan? So again, anyone over the age of 18, you absolutely need these 4 documents to create a basic estate plan. The first document is a will, and a will basically says how your assets will be distributed at your death. You will also in the will assign a guardian for minor children. In Nebraska, we call this someone a personal representative. That's the person who's responsible for the will. In other states, you might hear it called an executor. And the assets that pass through the will, okay, that we reassign using the will, are subject to something called probate. And we'll talk about probate here in a little bit and what happens during the probate process. If you do not have a will, the state of Nebraska will determine how your assets are distributed. Okay, and we'll talk about that here in a little bit. I promise you, you will not like the way that the state of Nebraska distributes your assets. Okay, the way they're distributed is based on your living relatives, and so it depends on how your family is currently structured or is structured at the date of your death, and that is how assets will be passed if you do not have a will. So we encourage everyone to write a will, and a will can be very, very simple or it can be more complex. But we encourage you to have a will. Now, the second document that you will need is a power of attorney. This will give someone the right or the privilege to manage assets on your behalf. Okay. So that's a regular power of attorney. Often we see those between spouses, and they are very, very useful, especially if someone becomes incapacitated. Um, and so it's important that we are able to still conduct business on your behalf, utilizing that power of attorney. Number 3 and number 4 are occasionally combined. Number 3 is a power of attorney for healthcare. The power of attorney for healthcare will allow someone to make healthcare decisions on your behalf if you are unable to make those decisions. Okay. So that's a power of attorney for healthcare. Okay. And the last one is a living will, also known as a healthcare directive, and it outlines your wishes for healthcare. Okay. So I have seen occasions, like I said, where the power of attorney for healthcare and the living will are combined. Okay, so but we want to make sure we have each of those elements in place. So as you look at that list, number 1 is enacted at death. Okay, so that will is enacted at your death, right? However, 2, 3, and 4 have quite a bit to do with before you die. Okay. Often we think of these kind of the end of life planning documents. Um, we think about if folks become mentally incapacitated, right? We're going to be able to utilize the power of attorney for healthcare, and the healthcare directive to make those end of life decisions for them. Okay. So 2, 3, and 4 will expire at death. So they are only valid while you are alive, and then the will enacts after your death. Now, we've assigned some people to help us with this process, right? We have a personal representative who's in the will. We'll have a power of attorney for the management of our assets, and then we'll have a power of attorney for healthcare. These are 3 separate designations. They can be the same person, but they do not have to be. Sometimes it's easier if they are the same person, but think about the types of people you want in these positions, okay? Especially when it comes to the regular power of attorney and the personal representatives. If someone is dealing with your business assets during your life or assisting you with your business assets during your life, it's probably easier for them also then to be the personal representative at death. When it comes to power of attorney for healthcare, I really encourage you to reflect on who the right person for that is. Give you an example. If you know me personally, you might know that my spouse is a germaphobe. He hates hospitals. He does not like them whatsoever. Okay. I can't get him to go into a hospital and visit someone. It's not his thing, right? I am not going to assign my spouse to be my power of attorney for healthcare. I'm just not. Okay. So again, they can be different people. Think about the strengths and weaknesses of each of those people, and make sure you've got the right person in the right place, but also think about continuity in assisting you towards the end of your life. The other piece about this is you need to make sure you have basically a backup in these documents. So you're going to assign a personal representative, and then there might be, if they're unavailable, there's going to be like a second name that you use there. We highly recommend that you do that. I don't personally think it's a good idea to name 2 people in that top position. So I don't like to use, Joe and Jan, right, in any one of these positions. Okay. I don't want them to have to make decisions by committee. Essentially, I want one person to have that decision-making power. But we do want to make sure that there's a backup for each of those, just in case the first person is unable to make those decisions. We've got someone else there to help. Okay. So be thoughtful about who you are assigning as your personal representative and your power of attorney for healthcare. Again, I think this is something that is really, really important as we talk about the estate planning piece. Now, any of these documents, 1 through 4, the will, the power of attorney for healthcare, the living will and healthcare directive, they can be replaced or edited at any time during your life, given that you are competent. Okay. So get something in place. Maybe today you're sitting here and you're going, I just don't know. Right. I just don't know exactly what I want. Even if you have something on file, right? It's better than not having anything at all. It's better than not having anything at all. So you can file these and then later you can come back and you can edit and update them. Okay. So make sure that you have these 4 documents. I don't see any questions in the chat, so I'm going to go ahead and move on. You may need or you may want these items. The first one you may need or you may want is a trust. Okay? We know a lot of farm and ranch families utilize trusts, but they are not necessary. The reason people like trusts, or a common reason for people using trusts, is that they do avoid probate. One of the challenges with a trust, though, is we have to really work with the trust. So we need to make sure that the assets are transferred to the trust, your assets are retitled to the trust before death, or there's a mechanism to transfer those assets at death. Okay. And usually that's what we call a pour over clause or a residuary clause in the will. Let me get a prop here for you. When I teach about trusts, I like to think about trust as a bucket. Oh, here's my little bucket here. So a trust is a bucket. What can I do with a bucket? I can put things in the bucket, right? So I'm going to take the things that I own and I'm going to put them in the bucket. It separates those assets from me as an individual. And as long as it's a revocable trust, let me say that again, as long as it's a revocable trust, during my life, I can put assets in and out of that trust. And I can also write the rules of that trust. So after my death, when do I want those assets to come out of the trust, right? I can pour them out of the trust, or how do I want those assets to be managed after my passing? Okay, for the benefit of people I say can benefit from what I put into the trust. Now, a trust becomes irrevocable, unchangeable at death. Okay. Usually you're going to be working with a revocable trust during your life, but remember, once you pass away, you cannot change that trust. Okay. So that's what a trust is. Trusts usually have nothing to do, or they can deal with, if you have very high asset values, we might be looking into trust structures. But also trusts can be very helpful if you have a complex family or family issues that you need to deal with. So I know we think about these buckets for ultra wealthy people, but let's say, for example, you have a disabled child that needs monetary support after your passing. Let's say you have a second spouse that you want to make sure that is cared for, or children that need to be protected from a second spouse, etc. So the more complex our family is, some of those bigger issues that we have, that's when we might look into a trust. Okay, so it's not just very, very wealthy people. Often we will use them for complex issues. Okay. Let me say it again. You do not necessarily have to have a trust as a farm or a ranch. Okay. We might utilize a trust but a trust is only one tool in the estate planning toolbox. It is not the only tool, and it might not be the right tool to help you address the issues that you have currently. Okay. All right. Number 6 is funeral instructions. I will tell you the families that I work with, they will tell you time and time and time again, one of the most comforting things that a family member can do is provide them with funeral instructions. It's usually one of the first things that you are going to deal with after someone's death, and having that even just written out. It doesn't even have to be paid for or necessarily planned, but just saying, here's what I want to happen, okay, for my celebration of life, whatever that may look like. So number 6 is recommended by tons and tons of people. It is not a legal document. It is not, they don't have to follow it per se, but it is very comforting. Okay. Number 7 is one I highly encourage everyone to do, and that's the bequests of personal property. So most attorneys will not clutter the will with personal property items. So the example I have on the screen is grandma's yellow pie plate, right? That cherished household item that means a lot to a lot of family members. Who gets that, right? So make a list. This list can be either typed or it can be handwritten. In the state of Nebraska, it must be signed and dated to be valid. Okay, it must be signed and dated. But you can basically make a list that says the grandfather clock goes to so and so. You know, this gun collection goes to so and so. Okay, so those are the bequests of personal property. And again, in the state of Nebraska, it must be signed and dated. It can be typed or it can be handwritten. And I encourage you to make sure that all of these documents are in a place that your personal representative, the person you assigned in your will, knows where it's at. Okay. On bequests of personal property, do not play the piece of tape on the back of the item game. Okay. This is honestly where families fight, is over the bequests of personal property. So what happens with the piece of tape game is magically there's 2 pieces of tape. There's pieces of tape with different handwriting. Do it the proper way, which in the state of Nebraska is a list that is signed and dated by the person bequesting that property. So I'm going to pause here for just a second, and I'm going to ask you a question. What of these documents do you already have in place? And when was the last time you actually reviewed these documents? For some of us, it's easy for 5 or 10 years to go by and for us not to have reviewed those documents. Remember, we absolutely need the first 4, and then we might add a few more there of 5, 6, and 7. Okay. I don't see any questions in the chat, so I'm going to keep moving on. There are common estate planning concerns. Again, remember, estate planning has to really deal with the distribution of your assets at death, your end of life, and the payment of debt. So the things that often come up are probate, federal estate tax, state inheritance tax, and long-term care. Okay, so we're going to go through each of these. I will be honest. Again, I'm not an attorney, and I'm not an accountant, and I'm not your attorney or your accountant. I've studied this stuff for several years now. But often some of your questions, I'm going to refer you back to your team. But I'm going to give you a broad overview of these topics so that you are more able to go into your team and ask direct questions. So the first challenge that a lot of families face is probate. And probate is simply the legal process that gives recognition to the will, appoints the personal representative, and is the process of distributing assets to the intended beneficiaries. Okay. Again, we make sure that all of the debt is paid. We make sure the assets are secured, and then we distribute the assets. Probate gets a bad rap, largely because of number one, and then, of course, down the list. One, two, and three, I think I hear equally, but number one is people say, I don't want the neighbors to know what all I owned while I was alive. It is public. You can go and read the probates. It can delay access to assets, which can be a challenge for farm and ranch families. The process of probate can take several months, maybe even more than a year. So that can be a challenge, especially if you are trying to run a farm or a ranch business. That access to assets can be difficult, and probate is going to cost you. Okay, it can be costly. It is a legal process. So you have the option. Do I get my affairs in order now? And maybe that costs me some time with an attorney and accountant while I'm alive, or will that cost be assumed during the probate process? So I think there's a give and take there. Um, and I think you have to recognize you're either going to spend money now or you're going to spend money later to get that estate settled. Probate does have basically a threshold, and each state is different. In Nebraska, if the estate is over $100,000, we will be going into the probate process. Okay. Now, does everything go through probate? No. There are assets that do not go through the probate process because they do not pass through the will. Okay, so those assets are assets that are titled to the trust, and then any account or titled asset that have the designation of a beneficiary or remainder man. So, for example, if I own a house as joint tenants with rights of survivorship with my spouse, that house does not go through the physical probate process because we were titled together. So when they die, the house becomes mine. Okay. There are other titling mechanisms, such as a life estate deed, but you can also watch for things like payable on death, transfer on death, and beneficiaries. Okay. Those do not go through the probate process. Here's my caution. If you are using a trust is again, it's not a tool for everyone, but you need to make sure that you actually put things in the trust to avoid probate. If your purpose for the trust is to avoid probate, during your life, you're going to have to put things in the trust. Okay? So you're going to have to physically retitle those assets. Okay? Make sure that that is done. It is going to cost you not only to set up the legal document of the trust, but it's also going to cost you to physically retitle the assets to the trust. And then you are going to have to be very, very thoughtful when something new is purchased or acquired that it gets put in to the trust. Okay. That's my soapbox on trust. The other thing about beneficiaries is making sure that your beneficiary designations match your current estate plan. Okay, the token example here is when someone gets divorced, their ex-spouse is the payable on death or transfer on death of a large retirement account or investment account. And guess what? It does not pass through the probate process. If they are the beneficiary, that is their account. Okay, so make sure that it all works together. It's got to work together. So if you have not done this recently, go back and go through all your bank accounts, all your investment accounts. In the state of Nebraska, titled vehicles can be payable on death or transferable on death, and then any other titled assets. And make sure you know exactly how those assets are owned and whether or not they will pass through the designations on the will or whether they will pass according to how they are titled. Okay. Okay. The next one is a federal estate tax, which is something that may not be a concern now, but if current laws revert back on January 1st, 2026, the level at which federal estate tax kicks in may be about half of what it currently is. So today, in 2025, if you as an individual, if your estate is less than basically $14 million, you will not pay federal estate tax. Okay. Now, we have to be thoughtful here. What will be included in my estate, right? And is that fair market value at the date of my death greater than that $13.99 million threshold? Are we getting kind of close or not? Okay, that's what we're looking at. Now, this is $13.99 million per person. So if you are married, under current law, if the estate is structured properly, a married couple could pass $27.98 million without paying federal estate taxes. Okay. The thing about this is you cannot, let's say you're over that $14 million mark. This cannot be a deathbed gift. Okay. There's a 3-year look back period. So again, we're looking at what assets you gave away pretty close to your death to establish whether or not you owe federal estate tax. And again, federal estate tax. Okay. Now, if the current law does not get extended, it will revert back to about 7 million in 2026. So we'll be revisiting this topic in about a year, and we might be updating these slides. But be thoughtful about how much asset value you currently own. Subtract out your debts, kind of start to estimate where you would be potentially at the date of your death. Okay. There are some exclusions to this tax. So number one, let's say I happen to own $16 million in my own name. But my spouse, because of how our things are titled, does not own that much and is not over the threshold. So we can do something called estate balancing between spouses, where I could gift unlimited gifts to my spouse as long as they are a US citizen. That would do what we call equalize that estate. Okay, so you can give unlimited gifts between spouses. So do know that I could shift some of those assets over to my spouse if that was necessary. There's also what we call the annual gift exclusion, which in 2025 is $19,000. I could give every single person who is on this webinar today $19,000. Okay, it does not count towards my $13.99 million unified federal gift and estate tax. Okay, so I will not be taxed on it, and you will not be taxed on it if I give each of you $19,000. Okay. That limit adjusts for inflation every year, so it goes up usually about every year. And you do not have to be related. Okay. The other thing that's cool with the annual exclusion is you can gift money, assets, entity shares, whatever you want, up to that threshold every year. Okay. Now, we can also do things like, let's say, again, I'm in imaginary land where I'm worth more than $14 million, right? Let's say I wanted to pay for my nieces to go to college, right? As long as it's a qualified education expense, which is usually tuition, and I pay it directly to that institution, right? I'm reducing my estate, and that is not taxable as a gift. Okay. We can also do the same thing with medical expenses as well. Okay. So there are options for reducing your estate below that federal gift and estate tax level, so that you're not paying that, I believe it's 40% right now, tax above that amount. Okay. We are lucky enough in Nebraska to live in a state that also has inheritance tax. So yay for us. Um, Nebraska inheritance tax is something that's very, very difficult to get around. Um, do know that it depends on how you are related to the person who passed away. So most immediate relatives will pay 1%, removed relatives will pay 11%, and everybody else will pay 15%. This was updated in 2023. There is currently a bill in the legislature, I think it's still there, to remove inheritance tax. But do know as of right now, it does exist. The one thing I will say about inheritance tax is this goes directly back to your county. Okay, so this funds a lot of county programs. So just make yourself aware of that bill and make your voice known of how you want that handled. Okay, last one, last challenge that a lot of people want to talk about is long-term care, nursing home care. Okay. There are really three options for long-term care. The first is to qualify for Medicaid. Okay. First is to qualify for Medicaid. Under Medicaid, you are limited to the assets that you can own. And I put a QR code there with the DHHS website so you can look up exactly what it is in Nebraska. It varies by state. So if you're in another state, what you can own will be different in another state. So we limit what you can own. And then what it'll do is it will have a 5-year look back period. So again, if I'm gifting assets in order to be able to qualify for Medicaid, I have to do that 5 years in advance of entering long-term care. Very, very challenging, right, to plan that 5-year period. Now, I want to be very clear. The nursing home does not take assets. Okay. What happens is you will be required to pay for so much care until you are eligible for Medicaid. So you will be selling off farmland, etc., to pay for care until you qualify for Medicaid. Okay. The second QR code that I have on there is from Ohio State University. Again, it's specific to Ohio, but I think it's a really good resource that goes through in greater detail about long-term care options. So my last comment about Medicaid is that in rural Nebraska, there are very few choices for facilities, and Medicaid is a double room. It is not a private room. Okay, so just thoughts about Medicaid. The second option is to purchase long-term care insurance. If you are on the webinar today and you are in your 50s and 60s, now is the time to be looking at long-term care insurance. But also go back and review if you have life insurance policies or annuities. They may also provide long-term care riders that may provide some coverage for you. The final option is to plan for long-term care. Okay. The annual cost of, the to estimate the cost of care, it's about $10,000 per month that we plan for, and the average stay in a long-term care facility is 2 to 3 years. So, yes, it's a significant amount of funds, but again, what's the right strategy for you? You need to talk to your team about what that plan looks like. Okay. I'm not seeing any questions in the chat, and I want to keep moving so that we do have time for questions at the end. And I want to talk about succession planning. Okay. So remember, estate planning and succession planning are different. And if we don't have someone coming back into the operation, we might not have to take the additional steps to do true succession planning. So we do know here in the state of Nebraska that 80% of farmers and ranchers don't plan to completely retire. Okay. Um, that is, it's an astounding statistic, but we followed that survey up from Iowa with a survey of our own that asked about why. Why are you not retiring? And over half said that they do not have a successor. They have not identified someone who's coming back into that farm or that ranch business. So if you're in that place, know that you are not alone. Okay. So what we are going to be asking ourselves are your heirs inheriting land, or are they inheriting a business? Okay. If they expect to sell that land after your death, we probably don't need a full-blown succession plan. If they are planning to maintain and manage that land moving forward, either as the farmer or the rancher, or as an LLC or a land holding company or something in that vein, we need to train them to do that. Okay. All right. So succession planning includes, but is not limited to, estate planning. It is a gradual and carefully planned shift to new business owners and managers. It includes timelines, milestones, and agreements. Okay. It's much more complicated to do a succession plan than it is an estate plan. The other piece about succession planning is it's not just death. There are other things like disability, divorce, disagreement, bankruptcy that can cause just as much challenge for a farm or a ranch family as the death of someone can. Okay. So I know that those are not fun topics to discuss. However, it's really important that what happens if dad dies first? What happens if mom becomes disabled? What happens if I get a divorce? Those are the kinds of conversations we're having when we're doing succession planning. Succession planning is a never-ending process. You are going to change, your business is going to change, laws are going to change, and therefore, if we're doing a succession plan, we need to review these documents during every major life event or every 3 to 5 years. Okay. We need to stay on top of this process. So succession planning, there are 3 main things that we're going to transfer. We're going to transfer the labor of the business, the management of the business, and ultimately the ownership of the business. Farmers and ranchers are great at step 1. Junior comes home, here's a pitchfork, go do the hard labor, right? That's the easy one. Management is where everyone gets tripped up. And the biggest key to success, and success being defined as farmer ranch survival, is making sure that you are doing management training of that next owner of the business. Often, actual ownership of that business does not happen until the death of the existing owner. Okay. We might see some ownership transfer, but often that ownership comes as a part of that estate plan. Okay. Okay. I want to get on my soapbox here for a minute. As a part of my work here at the University of Nebraska, I also work as the director of the Nebraska Women in Agriculture program. And that program is a wonderful program. But through my interactions in that program, I'm realizing we are skipping this question when we are talking about succession planning. Who is truly the next owner and manager of that business? So if you have kids coming back into the operation, that's great. But if you and your spouse are still alive, is the next generation going to be the manager of that business, or is your spouse going to be the manager of that business? And the number of times that I have calls from widows who have never negotiated a lease agreement, who have never sold grain, who have never culled cows, who have never made those level of management decisions, and now at 60, 70, and 80 years old are being asked to do that, is astounding. This is not just about training down, it's about training across. Okay. So how are we teaching the next person to manage this business? We're going to bring them along to those meetings with advisors and service providers. If we're talking about that next generation, we might have a requirement that they go and they work for someone else for a couple of years before they come home to our business so that they understand and have a little bit more worldly experience. And then we're going to consider handing over certain aspects of the business or giving them decision-making power over a small percentage of that operation, right? If we're talking about success, we've got to give them a little bit more decision-making power every year so that when it's my time to step back as the owner or when I'm gone, they know what it's like to not only make the $5 decision, but the $5,000 decision and the $5 million decision. Okay. Again, think about the triggering events within your plan. It is not just death. And then you are going to need structures and agreements in place that help with this process. So we've talked about the estate planning side of it, but your estate planning documents, if we're doing succession and transition planning, also have to work together with things like an LLC, things like a lease agreement, things like a buy-sell agreement, okay? So it's not just the will, right? It's also this is what's happening within our partnership or our corporation. This is the definition of how we've agreed to work with one another. Okay. Now, the tools listed here, unfortunately, we don't have enough time today to go into these tools. Maybe Ryan and the CAP team can convince me to talk about these tools more in depth in a webinar in the future. But we have to have something in writing, and not every tool is going to fit your operation. Okay. So last slide before I start to summarize here. Your situation is unique and not every tool in the toolbox is right for you. This is where you need that team of advisors who's going to say, this is how this is going to help you, and these are the options we recommend. What do you want to happen? Okay. Now, if you are in the webinar today and you're saying, Jessica, we need help. We do have another generation coming into the operation. I'm so glad that you're here, and I would encourage you to think about attending our Returning to the Farm retreat. It is a 2-day family retreat where we bring farm and ranch families together, and I get to have the hard conversations with your family for you. I get to start the dialogue, and hopefully we can start you on a path to a true succession plan. You also might be sitting in this room and saying, Jessica, I don't have anybody coming back to this farm or this ranch business, but I don't necessarily want it to be sold. What do we do? So we do have an opportunity here in Nebraska called the Nebraska Land Link program, where we connect people like you with what we call land seekers, which are usually new and beginning producers who are looking for the opportunity to farm or to ranch. Currently, we have over 200 land seekers across the state who, again, are excited for that opportunity to make farming and ranching their life. The other thing I will say is please check out if you have estate or transition documents in place and you're not really sure if they're the right documents and you need a second opinion. We do recommend that you reach out to the Rural Response Hotline. They offer free monthly clinics with an attorney or a financial counselor who specializes in farms and ranches. And finally, don't forget that the Nebraska Department of Agriculture also has resources related to beginning farmers and ranchers. If you are leasing your property to a new and beginning producer, you might qualify for a tax credit. Or if you need help with mediation in your family, we also have the Nebraska Negotiations Program. So I'm going to put up my contact information, and Ryan, we will take questions from the chat.
Thanks, Jessica. And we encourage you, if you do have a question, please type that in now in the chat box or the Q&A panel. A question did come in. about educational trusts, if you're familiar with those, and how they function for a farm after death, if assets like land can transfer into the educational trust.
I am not as familiar with the use of trust to pay educational expenses. So unfortunately, I would recommend that you go back to your attorney and your team and ask them that question. I'm just not comfortable enough to answer that for you today.
Thank you. And I don't see anything else right now. So last call, if you have any questions, get that into the chat or the Q&A. Just want to let you know when you close out of your Zoom window today, you'll see a really short survey evaluation. If you could just provide your feedback on that, it should probably just take about 30 seconds to do. That's really helpful to us as we evaluate all of our webinars and plan for future webinars. And we'll be back with our regular Thursday webinars next week with a look at the ag workforce and building a resilient ag workforce, where we'll be talking about enhancing retention for ag employees, as well as the basics of hiring H-2A workers. We have one more question here. How do you sign up for the workshop series? Is that maybe returning to the farm, or I don't remember if you covered that.
I did, and I did put the link to the returning to the farm there, and I'll stick it here in the chat as well, the returning to the farm workshop. Again, if you are interested in attending returning to the farm, we highly recommend that you bring as many family members as possible to that. We're going to be diving into deep discussions, and it's a lot easier when the bulk of your family is there, and hopefully all of your family members who need to be in that discussion are there.
Great. And we had another question just asking about critical documents to be filed to state and county inheritance.
So Paul, I'm not sure if I understand your question correctly. So I'm sorry if I missed the mark here. You can file your will with the county. Very, very few people do. Typically, your will is with your estate planning documents, and your attorney keeps a copy of that will. Only when you go through the probate process will you actually get to the point where you're filing the inheritance tax amount. So I hope that answered your question for you. And again, go back to your team and make sure that you've got the right documents in the right place.
Thanks. Another question that just came in: if a person wants to keep things like they list cash and guns out of trusts and wills, how do you keep it out of probate?
That is a question I think you need to ask your team, because they are, well, cash is not personal property, but the other items there would be personal property. So again, you would need to talk to your team about how that works.
Great. Well, I don't see anything else right now, and you see Jessica's contact information up there on the screen. So if anything comes up, you feel free to reach out to her, and reach out to us as well at the Center for Ag Profitability. Looks like there's one more here. So how do you convince your parents that they are transitioning a business and not just dividing assets? This person mentions that they are farmer, one of 4 kids. So I'm guessing that's
Yeah,
doing the on-farm work potentially.
yeah. I think this is very, very challenging. And I sympathize with you at that moment where you're trying to say, is this business truly what we're passing, or is it assets? So number one, try to open up those channels of communication with your parents. I actually like writing a letter to them. It helps you to kind of form your thoughts of how you would address it if you could, perfectly word things. When I talk, sometimes my mind gets in front of my mouth and I stumble too much and the right words don't come out. So I personally like to process through a letter. and provide them with that, provide them with time and space to think, and then think about what possible alternatives would be. So, for example, if they're dead set on we're going to divide assets equally amongst heirs, um, can you put in something like a lease agreement that allows you to lease those assets from your siblings for your lifetime? Is there something like a buy-sell agreement that we could put in place that would allow you to purchase those assets should any of your siblings want to sell, or something like first rights of refusal, which say if they decide to sell it, that you have the first shot to purchase it. So there are things that even if they say it's going to be divided this way because it's fair, are there things that can still keep you in business? Um, I'm not saying it's going to be easy to do that, right? But that we can put in place that at least give you more security in knowing that you still being on the farm or the ranch um, is not going to end at their death, right? That you have the shot, and then you can financially prepare for that to say, I know that this will not be gifted to me, but we can put these other documents in place that again are beyond the estate plan, that say the farm or ranch child has these rights or these opportunities, and that's not to disadvantage the other siblings, but to ensure that that farm or that ranch business moves forward.
Great. Another question about if you have any advice on where to keep documents for family to access.
So, most importantly, you need to make sure that these documents are secure and that the personal representative knows where those documents are at. Um, Often it's you know, this drawer of my desk has has the instructions for how to access those documents. So that might be a gun safe, that might be or any safe. It doesn't have to be a gun safe. It might be a safe. It might be a fireproof box. The only caution I have about safety deposit boxes is that they need to know the number and they need to have the key, and with any of these locations that you are updating those documents regularly, right? So if I go in and I update my list of uh, personal bequests, personal property bequests, right? That I didn't just leave that on my desk, that it actually gets put with those, with the other estate documents. Okay. So wherever that is, you want it to be a secure location. Um, and you want to 100% make sure that that personal representative absolutely knows where that location is and has the key or has the code to get into it.
Great. There's another question asking if you could say more about the state inheritance tax.
If that person would type a little bit more of a specific question in there, I'm not sure exactly what more you want me to say about it.
All right, and I'll give them an opportunity to do that. There's a follow-up question from asking if it should be a secret how assets are going to be split up.
I think it depends on the family. My personal preference is no, that it's not a secret. I think that we as family members have expectations, and disappointment comes from our expectations not being met. And so, if I expect to inherit X, Y, or Z, and I don't get that, um, that can be challenging, right? But if I have the expectation, for example, that, and I've seen in writing, right? I think there's two pieces to this. There's the expectation and there's the reality, right? If I expect to have that farm or that ranch split equally amongst me and my siblings, and I know that, and I've seen it in writing, and that's what happens, right? I'm not necessarily as upset at the end of that process. However, if I'm promised, if I'm the on farmer ranch kid and I'm promised someday this will all be yours, and I never see it in writing, and then at the end it's split equally between me and my siblings, I'm dumbfounded at that point, right? I'm really in a difficult position because my expectation does not meet my reality. So I don't think it's enough just to say what's going to happen. I encourage families to share physical documents, legal documents that show, as of today, this is our plan. Now, I want the reality check here that plans can change, right? If it's something that passes through the will, or if it's something that's in a revocable trust, that can be edited, modified, updated until that person's death. Okay. The other piece is, and I see this occasionally happen, is let's say it's your parents are living, mom and dad are both living, but after the death of the first parent, the living parent goes and changes the plan. So again, do know that there's possibility of things being edited or modified or updated, and sometimes that's because tax laws change or something like that changes. So do know just because that's how it is today does not mean that that's how it will be in the future. So we need to revisit that discussion. And if you go back to some of our previous webinars, we do great. We've had a few webinars on like family business meetings, and that those items should be brought up during those types of management business style meetings.
All right, thanks, Jessica. And then the previous question asking for more information on the state inheritance tax. I think that this person is looking for the slide again on the conditions on the limits to what's taxable.
So again, I encourage you to scan the QR code there. There's article, and I'm sorry, Ryan, I didn't include that, but that's the article from Dave Aiken, if you want to find that for this person. Those are the assets valued as the date of death. Typically, there are some caveats to that, but usually it's fair market value at the date of death. So anything over $100,000 would be taxed at 1% for class 1 relatives. And again, the recording of today and the slides will be posted online within the next 24 hours at cap.unl.edu.
We'll find that article and put it in the chat here.
Oh, John has a question. Does the trust keep creditors from access? So actually, yes. If it's structured properly, a benefit of a trust is that it can limit creditors from accessing what's in the trust. But again, we need to have assets in the trust, and they actually have to be in it in order for that to work. We can also have something called a spendthrift clause within a trust that makes sure that beneficiaries of that trust do not spend that money too quickly, so we can limit the access that they have to the assets within the trust as well. So great question.
Perfect. Well, thank you, Jessica, for hanging on here over time. Question: if you privately meet with farm families just came in, and I think that's something you're available to do if they're in your area.
Yeah, what I will say, I'm gonna go to another slide, and sorry to click through here. We here at the Center for Ag Profitability, we have a few of us that do meet with farm and ranch families. But what I would say is we like to meet with families who are in those beginning conversations and who are still friendly to one another. If you are in a situation where families are adversaries, family members are adversaries to one another, then we will recommend you to the Nebraska Negotiations Program. So I put the Nebraska Department of Ag slide back up for you so you can look at that program if you need true mediation, right? If you can't sit down in a room together, we're going to recommend you to the Nebraska Department of Agriculture. But of course, you can email me. There, again, are several of us across the state who do this, and we can talk about what that might look like. But I would also encourage you to attend the Returning to the Farm event as well. That's a great opportunity for us, again, to have some of those difficult conversations with you and with your family, and kind of allow us to help you get through some of that awkwardness there at the beginning as you begin to have these conversations.
Cool. Someone also just asked, what's the best way to pay the least inheritance tax?
So again, I'm going to refer you back to your team of advisors. If that's one of your goals for estate or transition planning, you need to work with them, because I don't have enough information about what assets you own and what gifting strategies we could implement, et cetera, to answer that fully.
Great. Well, thank you very much, Jessica Groskopf, for a great presentation today. And thank you, everybody, for attending and for all the great questions. Again, you see Jessica's contact details there on the screen. If you have anything that you'd like to follow up with her on, please reach out to her. And again, we want to thank you for attending today, and I hope you have a great Thursday afternoon.
Thanks, everybody.